Morning. May it please the court, my name is Jessica Cochran. I'm here with Dominic Rapiano. We represent the Petitioner Manhattan Avenue LLC, who is the plaintiff in the underlying case. I'd like to request to reserve 5 minutes for rebuttal, please.
You got it.
Thank you. We're here today requesting this court to quash the trial court's order, which denied plaintiff's motion to compel a request for a site inspection and granted defendant's motion for protective order. This case involves a discovery order, and certiorari review is appropriate in this case as the underlying court's order departs from the essential requirements of law, causing material injury to the petitioner throughout the remainder of the proceedings in the trial, and effectively leaves no adequate remedy on appeal.
Let's talk about that for a minute. It can't be remedied with appeal. Most certiorari cases, of course, we look at the jurisdictional component first. And most certiorari cases where the petition was granted do involve cat out of the bag, the granting of discovery. And here, what you have is the denial of discovery for soil tests that you all want from the city's land for things that aren't on your property now. You've got 4 items of pollutants that you know of, and they meet the Venn diagram on the city's property. The trial judge determined that I'm not sure if she said relevant or not, but that's the basis on which she denied this order. So, in what way is this going to? Is the denial of this discovery going to cut out legs from under your claim to where you can't try it? And specifically, if you think that more of these pollutants than your soil tests have already revealed are on your property, why can't you test your property? And if you have identified the presence of pollutants that are not already on your property, then you could go back to the trial court and ask for this. And then or if they aren't there, it doesn't matter. So where's the irreparable harm?
The underlying complaints, the allegations, obviously what we would look at to determine relevancy. There are multiple claims in this case.
I'm not asking about relevance. I'm asking about irreparable harm if you can't get this discovery.
Sure. Well, the irreparable harm here is that there's no other way to obtain this information, and the allegations are not that that it's only the pollutants that showed above the remedial measure. There were also additional pollutants. If you look at the exhibit A that showed that map, which is what we were requesting to test for all of those. It was defendant's decision to only permit us to test ones that were found on our property to be above a certain level. However, that's not the claim that we're making. The claim is that any of those pollutants, if they're found on landfill 25, then we have a claim that it decreases the property value. The defendant in the underlying case argued that it would only be relevant for us to obtain information on the pollutants on landfill 25 for those pollutants that were above a certain level. That is not what the claim is. It would be relevant for us to obtain all of that information, because that is essentially our argument, is that any of those pollutants, regardless of the level of them found on our land, if we determine that it's from
Back to my
25,
have you done any additional testing to support the request for what you now want?
that entire test that shows all of them, and then it highlights the ones that were above that level, that supports what our request was for, because it did find all of those contaminants on your property. Correct. So we wanted to test for all of those on our property on theirs. They, however, determined, based on their own determination of what was relevant, that we could only test for the ones that were above the cleanup level. However, that's not our argument in the complaint, is that the damage is only because of the pollutants that are above the cleanup level.
Here's what I'm struggling with on that, is that you're If two different styles, the chemicals that you now want to test for, that you're saying you detected some measure of on your property that you haven't tested for previously on city's property, let's put that over here in this side. It seems to me that it would be an odd situation where we would say certiorari lies to give you access to this litigant's property, their private property to test this. But apparently it hasn't risen, there isn't enough cause for you all to allege in good faith an amended complaint that would now list all of those chemicals that you say you've detected on the property. You see that disparity that I'm trying to articulate, not very well apparently. That you don't have a good enough basis apparently to amend your complaint to just allege all of those other chemicals in the silo, but you're asking for this court for certiorari relief to test for it.
Well, the original request for inspection was for all those chemicals. We're not coming back asking the court for an additional request. That was the additional request, and I understand your position that maybe the complaint. I understand the query that maybe the amended complaint should list all of the chemicals. However, we don't know them all yet. We're trying to do discovery to determine that. There's certainly a good faith basis to request that information, as that's the only way we can get it. We've requested documents. However, these contaminants were put on the property in the 70s and 80s.
I mean, you specifically listed certain chemicals in your complaint. Now you're wanting to go back to test for chemicals you haven't listed, but you have to plan. You get pleading, like front center, hey, these are chemicals you're alleging they have polluted our property with A, B, C, D, E, F, G. It gives a stronger basis for the trial to say, I need to be able to test for A, B, C.
And the complaint doesn't allege any specifics. It alleges that there are chemicals and pollutants. It doesn't allege any of them that, so it's not like we allege 5 and now we're going back to get 10 more. We allege in general.
Kind of makes it even trickier, right? Like if I'm complaining, let's say I buy a lawn, site is for a lawn patch. We know have a tendency to have some residual environmental effects before a gas station. And I'm a neighboring property owner. At some point in the pleading, don't I need to identify what it is that they're polluting my property with? Or what are you saying now? You just said you're polluting, that's it, boom, that's good enough to get us.
To allege a claim, if they thought that was improper, file a motion to dismiss. That's not what happened here. That's a proper claim alleged under the statutes that we're arguing that there are regulated contaminants. There's nothing that requires us to list out which contaminants we believe they are. However, we tested on our property to determine which ones we're alleging could be from these other properties. It's to prove our case, we have to determine whether those chemicals are coming from this property, this property, this property, where they're coming from. So the irreparable harm is that there's no other way to obtain that information. We've asked for documents.
Let's look at this from a little bit different perspective. What if you had gone ahead and managed to get the discovery, soil testing, and what you think, what I think you're speculating on here is that the chemicals that don't meet the cleanup level, that you might find some more of those on the city of Tampa's property and so on and so forth. And this is a hypothetical. What if the trial judge got this discovery and what you found is trace elements, right? For lack of a better term. And what if the trial judge says, I'm going to grant the defense's motion in limine? Is that certiorari worthy? Is that going to give you irreparable harm sufficient to invoke our certiorari jurisdiction?
For a motion in limine?
Yes, that's my question to you. We don't have that problem, but let's just play this tape out. You get the discovery, the city moves in limine, and the trial judge says, granted, I'm not, these are below the cleanup level. That's it. You got the discovery, you still can't use it. Is that certiorari? Or is it a curable on plenary appeal?
Right, I think the the question assumes that the only injury here has to be chemicals that are above the cleanup level. That's sort of the whole
Well,
point
the
here,
trial
that's
judge
not
can
the
make,
injury.
the trial judge can make that assumption in ruling on motion limiting, just as she may have made that assumption in ruling on your motion to compel. And so my question, which goes to not the merits of your claim, but our ability, your ability and our ability to exercise, the ability to invoke and ours to exercise certiorari jurisdiction, was it, this is not the standard tool for refereeing a discovery dispute.
Right.
This is an extraordinary remedy, and it, under our own case law, it is only granted where the discovery is absolutely critical to the claim that you have pled. And I'm struggling with, and I think Judge Lucas asked this question in a different way, exactly how this is critical in a way that if you had to address this on plenary appeal, there would be no way to cure it on review.
Well, so I think to answer the prior question about the motion limiting, in that hypothetical question, we would know the result of the testing that was done. And I think that's the difference here, is here we can't correct it because we have no way to determine what the outcome of the testing would be. And
I mean,
what those
let's
effects
say you
would be
get
on
a
the case.
plenary, right? You go to trial, you get either a zero judge, you get an over, you lose, or you're dissatisfied with the measure of damages because you weren't able to prove additional contaminants. You come back on plenary, what happens then? They've cleaned up so you can't test? Is that the worry?
Sure, I think there's either that or the fact that we would have to come back and redo all of the testing, which
That's not gonna be a ground for certiorari. We know that, right? The
I think
cost of
that-
having to go through two trials,
Right.
that doesn't get you a road.
right, agreed. I think the irreparable harm here is going back to, and I understand the position that typically denials of discovery, those orders are not, or it's a limited type of order that is reviewable in certiorari. However, if you look at the case law discussing in the HEPCO case that we cited to in our brief, which cites to a second DCA case, Giacalone v. Helen Ellis, the courts essentially both agree that orders denying discovery where the discovery request is relevant and reasonably calculated to lead to the discovery of inadmissible evidence effectively eviscerates a party's claim, defense, or counterclaim, warranting cert relief.
What
And the
was
HEPCO
the discovery at issue? Case you call?
So the Giancarlo case. HEPCO case was depositions.
Wasn't it, it had to do with medical provider pricing, is that right?
The HEPCO case had to do with an argument that there was an agreement or lack of an agreement to obtain some data. And the defendant on that case objected to depositions being taken, saying that they weren't relevant without actually providing any support as to why they weren't relevant. The judge agreed, she denied the motion to compel, entered a motion for protective order similar to this case, without finding any materiality, without supporting as to why it was relevant, and without finding good cause, which is required under a motion for protective order, similar to this case where the underlying judge essentially agreed with the defendant's argument that the discovery request wasn't relevant, even though defendant's argument of relevancy, their definition was that we had to have evidence to support our discovery request, which is certainly not accurate under 1.280.
When the city characterizes, and not without some foundation, your request as likened to a fishing expedition, and that is never, in our jurisprudence, to the way I understand it, a ground for certiorari relief. Tell me what your thoughts are on that, and I'll tell you you have about a minute and a half before you get into the go.
The finding that it was a fishing expedition, I think that entire order is against the essential requirements of law, because that finding is not a material finding. There was no actual support, no actual basis to say this isn't relevant or this isn't reasonably calculated. Summarily just saying it's a fishing expedition is not appropriate. And there's a case that is cited to in HEPCO, It's the Towers case, which is a fifth DCA case where the court specifically grants certiorari relief, where the court made a wholesale characterization that discovery sought was a fishing expedition when it was clear from the request that it was a relevant request. This is the exact same order in our case. The judge essentially just said, it's a fishing expedition and gave no other findings. I guess we can presume that the judge agreed with opposing counsel's inaccurate definition of relevancy, which is that we need evidence to support a discovery request, which is not what the definition of relevancy is or what the scope of discovery is. The fact that she called it a fishing expedition without anything further, I think is the issue here. In addition to the motion for protective order being granted without any grounds to say it was for harassment, it was for undue burden
I
expense.
think there had to be a finding on fishing.
Absolutely, and the HEPCO.
At all, it's your time, you can do with it what you want.
Okay, I'll just close out by saying I think the HEPCO case is pretty on point here with respect to the order, the motion for protective order, where the HEPCO court essentially, similar to this court, just granted the MPO without any grounds to support the MPO. The specific rule for an MPO says that you have to have those grounds. And there, not only was there nothing in the record to support the motion for protective order, the judge found no grounds. The motion for protective order was essentially an attempt to object to relevancy when they already waived it. It's not a proper motion, nor were there proper findings in the order. Thank you, I'll reserve.
You got about 4 minutes.
Thank you.
Morning, Your Honors. May it please the court. My name is Timothy Harry, and I represent the respondent, City of Tampa. I'd like to reserve 3 minutes for rebuttal.
You don't have a cross appeal. Do you have a cross appeal?
No, Your Honor.
Okay, I think you've got 20 minutes.
Okay, yes, Your Honor. We will respectfully request that the court deny the petition for writ of certiorari from the trial court's October 15, 2024, order denying the petitioner's motion to compel site entry for testing. The petitioner here is a sophisticated commercial purchaser. They purchased the property for $500,000. They knew at the time of purchase that the property was previously used as a landfill with potential contamination. The very same day that they purchased the property, they sent the city a demand letter requesting that the city pay them $5 million. Later requested even more money than that. The plaintiff sent a complaint to DEP to persuade DEP to take enforcement against the city's landfill. The city declined to do. The city is very familiar with these landfills. This is a closed landfill. The landfill at issue in this case has been closed for more than 40 years, since the 70s. The petitioner requested site access for testing for 17 different constituents. This is in groundwater. At the city's site. The city agreed to allow site access, subject to, our objections and the standard site access agreement. The petitioner executed the site access agreement, limiting the testing to 5 constituents. The city allowed 4 days for site inspection.
Can you walk me through something real quick? It's just,
Sure.
It's something that occurred to me. If this isn't in the record, or this can't be gleaned from the record, just tell me. Is there something about the nature of the testing itself, that when they came on initially to do, that they weren't able, that the kind of testing they did was such that it was insufficient to detect these other chemicals? Or is it in order to test these other chemicals, you have to do a different kind of testing, like it's more invasive, more broad, more widespread? I think like soil, where you dig down and pull up stuff and look what's in the dirt. Yeah, but I don't know. If it's not on the record, then just tell me.
It's not really in the record, but I think I think it can be inferred from the record, and it's basically they would just have to test for some additional constituents. So there would be some additional testing that would have to take place as far as the.
So whatever it was they did, it would be the same thing. Just they're looking for something new. More
or less, that's correct. Back at the lab, they would test for different things.
And given that, I mean, I don't know if this plays into our certiorari jurisdiction or not, but I mean, it's one of those kind of things like, it's not like they're asking you all to sit a bunch of people for depositions or, produce like some huge voluminous mound of documents, searching through, closed servers to find them. They're just saying, want to get on your land, all take lost in whatever it is they do, and then we're gonna leave and then do our own testing. But I mean, does that play into this analysis at all? That it's just really not that big of an difference. It seems like as to what they're asking to do.
It is, it's more on the testing itself is invasive, because it's invasive, because they've got to go in, they've got to install wells, they've got to test, there's the potential ramifications of the testing, on the city.
Ramifications, it's one of like clear cut your closed fill. I mean, what are we talking about? You're not gonna build houses.
No, but, well, I mean, they're going to, the city does use the site, for other purposes and for disaster purposes. It's a permanent debris site. After hurricanes, there was
like all the trees. That's where my yard was.
That's where your yard waste went. Yes, that's correct. For a period of time before it was transferred to another facility. So there is uses for this facility. It's closed as a landfill, but it is used for other purposes. The potential effects of this, it's intrusive. It's the city's testing it exceeds the scope of relevancy. They've done testing on their own site. The best evidence that they showed was the map and the testing map that they produced, which showed that
hey, listen, we're just generally leading contaminants. We've been and as to what that pollution entails, that's what discoveries. You seem to be suggesting no. Relevancy is whatever. I don't know, but whatever the list of chemicals that rises above the threshold is.
yeah, and those are set by the Florida Department of Environment, which sets the groundwater cleanup target levels. Those are the regulatory limits where.
But is that plaintiff's theory?
That's the case law. That's the law.
That's a regulation. I'm asking what the plaintiff's theory of the case.
The plaintiff's
theory of the case, like reading their complaint, is look, whatever the thresholds are, great, you can argue that to the jury if you want. But our position is that you have contaminated our property at some level that it otherwise wouldn't have been contaminated with, and so therefore we should be allowed to come back and do a second site testing.
Well, they're statutory claims. They're basically stepping into the shoes of the Florida Department of Environmental Protection. And so what they would have to prove at trial is that the constituents exceed the groundwater cleanup target levels or some other levels that are higher than that. And so that's the threshold. That's if the DEP itself were to come to us and they found some levels, but they were below the groundwater cleanup target levels, the DP would not do enforcement of that. It's not the mere presence, it's the presence at a certain level, which is what's relevant to their claims. And for the 5 ones that they had some relevant information that they could show based on their best evidence, based on their testing of their site, that they had a plausible claim, we allow them to come do testing for those. It was the other ones that they had already done the testing and excluded them as relevant factors. They know that they're not exceeding it, the levels for those other 12 constituents or 15 constituents. They know that that's not a problem. So there's no need to go test on our site for it. There's no plausible claim that we're having an impact to them.
So under your theory, even if we had jurisdiction, assume that we can decide this case in certiorari, your theory is there's no principle of law, the clearly established principle of law that's been violated because the trial judge was well within her discretion to limit the discovery to the constituents that exist on their property pursuant to the testing over the limits.
That's correct.
I've got that right? Okay.
Yes, that's correct.
And the trial judge's decision on that under whatever standard, posture would be discretionary, is that correct?
That's correct. And under the KD versus Wells case, I mean, the trial court has very well recognized broad discretion to manage the discovery that's before it. And that's exactly what happened here. The judge had the evidence. She looked at the map with the constituents. We showed that to her during the oral argument. We walked her through the whole analysis.
And I'm gonna ask your opponent this on rebuttal, or I'd like her to have the answer for me. Is there a certiorari case where the trial judge's standard where cert was granted because the trial judge abused their discretion?
I mean, there can be cases where a judge can go beyond what's allowed and discovery can be granted. There are certainly cases that say that there is a certain limit, you know, and what the petitioner cited was the HEPCO case. Okay, the difference between HEPCO and this case is in HEPCO, they were asking for, I think, 17 depositions. And in HEPCO, the party seeking discovery made a proffer and said, here is why, you know, a number of these witnesses are relevant. This is why we should get this discovery. And the judge in that case issued a blanket discovery, okay, ignored the evidence of relevancy and issued a blanket discovery order. And that was the problem there. We don't have that problem here. They made a proffer to show that there was some evidence that was relevant. We allowed that discovery. What we didn't allow was what was irrelevant. That's what the judge found was irrelevant and found was a fishing expedition. And the Trump case that's cited by the petitioner says that fishing expeditions are not the type of cases that petitions for certiorari should be granted. So what we have here is that there's no material petitioner. There's no departure from the essential requirements of law at issue here. You know, the Noya case says that you know that there can be an objection if the discovery is outside the scope of permissible discovery, and the petitioner has an adequate remedy of appeal. The denial of site entry does not cause irreparable harm. Like Your Honor suggested, if they have relevant evidence that they can go back to the court to ask for more discovery based on additional testing that they do on their site, they can do that. And so they have an adequate remedy, not just during the case below, but also on appeal to make an argument later that there was some type of irreparable harm. But petitioners claim that it doesn't know what it might find isn't a valid justification, and it just confirms the speculative nature of their requests. The city should not be required to open its property to speculative private testing, absent a demonstrable and particularized need, which does not exist here. And the trial court's decision below prevents the abuse of discretion as a litigation weapon rather than a truth-seeking tool. The petitioner has failed to meet its jurisdictional threshold. The trial court here has exercised its proper discretion, applied correct legal standards, and protected against speculative intrusion. We respectfully ask the court to deny the writ and affirm the trial court's ruling. Thank you, Your Honors. If there's any more questions, I'm happy to answer them.
Thank you. I'd like to start answer to my question.
It was whether there's a certiorari case where the judge abused her discretion. Is
Yes.
that the question? Okay.
It was a violation of the clearly established principle involved in abuse of discretion.
Right, and I believe that occurred in the HEPCO case where the judge abused his or her discretion in denying the depositions by finding that they were immaterial without actually having any findings that these depositions were immaterial, other than relying on the opposing counsel's argument that they're not relevant. The court specifically pointed out that there's no rule or case law that provides that the opposing counsel is the one that decides what is relevant, what is not relevant. It essentially what happened in HEPCO is what happened in our case. Opposing counsel argued that the additional testing was not relevant because they were only looking at one of our claims, which is to argue that the levels were above the cleanup, requirements. However, another of our claims alleges just the pollutants themselves, regardless of levels, is causing injury. And that when we show which pollutants are on our land, that shows that the land decreases in value, can't be resold. And that discovery is what is relevant and necessary to prove the claim. I think that the discretion is very similar, or the abuse of discretion is very similar in that case, as well as in the Giancarlo case that I mentioned previously, where it was under the same rule as our case, 1.350, where the court denied a motion to compel a discovery request. It was a request for production, specifically requesting documents to prove their claim. And although the court found that there were additional documents that they could obtain to prove relevant matters, that although that these documents, the request for documents, it was a relevant request. And because it was relevant, the denial of that request without any support or any material finding was sufficient for certiorari jurisdiction.
Well, just quickly, in the Jacqueline case, the discovery was the hospital's pricing information. And the plaintiff's claim was that the hospital was overcharging. And the only person who had the information on pricing was the hospital. So think about it, not in terms of that information here, the plaintiff, they know, you've got at least these 4 contaminants. And anyway, I don't want to use up all your time, but.
So that's the issue here, is that our case is not just based on these 4 contaminants. Our case is based on any contaminants that we find on our property, then we should be able to test to determine where those come from. The evidence of these 4 contaminants is not the same thing and would not permit a jury to determine damages or an injury as it would if we were to obtain information on all of the contaminants. The fact that we've obtained 4 does not mean that's all we get. That's not how relevancy works. That's not the proper interpretation of the rule. And although opposing counsel's argument is that we need evidence to serve a relevant discovery request, that's certainly not the law and not what the rule says, because though the landfill 25, the city, is the only one who has that information of whether those contaminants are on their property. Similar to Giancarlo, where they're the only ones that have that information. If in Giancarlo, if the court said, okay, hospital is the only one that has that information, I'll let you get half of it, that would be similar to this case here. Okay. And I think the Giancarlo case and the HEPCO case are pretty on point with our case, in that certiorari review is proper. I think it's pretty clear that the departure from the essential requirements of law was that the court found there was not a waiver for relevancy, and the court entered an order without material justification or any grounds to support an NPO, which is. Thank you.
Thank you. Very well. Our next case is Florida Forever.